right, we will hear from the appellant.
Good morning, Your Honors.
Good morning.
Lou Wardlaw from Memphis, Tennessee. I represent Niel Prosser and Sarah Prosser, the appellants. I'd like to take 10 minutes for my main argument and reserve 5 minutes, please.
5 minutes for rebuttal. All right, sir, you may proceed.
Thank you, Judge Stafford. The Prossers seek relief from the Shelby County Chancery Court's June 28, 2023 order of judgment, which itself affirmed a June 22nd, 2022 decision by the Memphis and Shelby County Board of Adjustment. That initial hearing before the Board of Adjustment, or the BOA as it's called in everybody's briefs, addressed a zoning letter ZV 2022-259 that was issued by the Department of Development, sometimes called OPD, sometimes called DPD. The Prossers, my clients, and Ms. Sarah Prosser is here, own a home at 206 Stonewall Street in Memphis. And Friends for Life, FFL, or sometimes called Friends for All, FFA, is a nonprofit corporation that owns properties on Poplar Avenue immediately adjacent to them. The Department of Development staffer that drafted the zoning letter and the papers that were put before the Board of Adjustments called that property an obviously very residential portion of this neighborhood. It's zoned residential. There are no grandfathered uses on it. And that's the baseline. That was changed by this zoning letter. We submit, and it's been well briefed, I think, by all sides, but our submission is that the zoning letter illegally granted virtually carte blanche to FFL to expand uses of the property that had never existed before.
What are those uses that you're concerned about?
Well, I can and will, Your Honor, tell you uses, but it's really anything that goes beyond an office use. More simply, it's anything that's not allowed by the underlying residential zoning or allowed by any of the applicable variances that have changed that zoning. And that comes down to the same.
You mean it was unlimited?
Excuse me?
I mean, was it unlimited?
It was not unlimited.
Okay, it sounded like you were saying it was.
They have said, I think, it's our submission through the zoning letter, you can do what we have called a virtually unlimited grouping of social services, on-site provisions to client patients that far exceed any conceivable office use. The Prossers have no objection to their using the building as an office for the services provided by FFL. They don't have any objection to their using legal uses available to them under residential or under the applicable 1950s zoning amendment or zoning variance. As I'll address in a moment.
But
Excuse
let
me,
me
Judge.
ask you a question about that. What were the variances that were allowed prior to this litigation?
Okay, yes, Your Honor, and I'll skip to that right now. That there was a variance allowed in 1957, I believe.
I think it was 51.
Excuse me, 1951, thank you, Your Honor, that allowed this residential, it was a house, it's a large house, allowed it to be used for headquarters home, period. In other words, it allowed the Baptist Brotherhood then to conduct their office uses, their administrative uses to do that mission work which the Baptist Brotherhood did. What they actually did, I think, is fairly well established in the proof that was before the BOA. It was uncontroverted that they did the administrative side of that here. Office uses. It's office uses specifically for a purpose, but it was office uses. Then there's a 2017 variance that I'll get into a moment that we say has lapsed. But if the court disagreed that it had lapsed, it still only allowed office uses. and it restricted some of the office uses, no TV.
What about the medical office or physical therapy office may be permitted that was in the minutes of the board?
Well, I'll go back to the lapsing of that variance in a moment, but if that had not lapsed, then that would be allowed under that variance, the specific language. As this court knows, and I've been here several times arguing on these same issues, a variance is read to the strictest sense. It is taking the law. Here's the law that is published to everybody that you must follow, and we're going to change it. So by definition and under Tennessee law, it is to be changed to narrowly address what it is. If that 2000 variance still applies, then it would apply to the limited language in the variance itself. And going ahead a little bit, before I jump back to why it should not apply at all, it would apply to the limited language in the variance itself, not the documents that were given to the Board of Adjustment beforehand, not documents that were created by the developer after the fact. The document, the minutes, are how the Board of Adjustment speak, and that's what it is. And that's in the record many, many times, and it's been heavily cited in my briefing. Judge Golden, you had asked what are the uses that the prosecutors say are illegal, and I've given you the broader answer of that. Anything beyond residential, which is allowed under the law, anything beyond the 1951 variance, which allowed headquarters home, and anything beyond the 2017 variance, to the extent it hasn't lapsed, and we say it has. But the uses that have been publicly offered by the Friends for Life and were stated as uses at the Board of Adjustment hearing are the showers and washers and dryers to their clients, and meals and snacks, and a teaching kitchen, and a full pharmacy and mental health services, condom distribution, medical clinic, including urgent medical care and testing, and those go far beyond even what would be allowed in the 2000 variance had it not lapsed. Much was made in the appellant's, in the appellee's brief.
Where did they state that? Where is that? Where are those requests made? In other words, like on the variance, like for instance, the 2017 variance, it says requesting use variance from section 2.5.2 to allow office uses. Where was the request made for all these various uses that you're saying they?
And let me clarify, the 2017 variance was not made by FFL.
I know, I understand.
And it's not under appeal here. Where FFL stated that they could fit in the uses they proposed into that 2017 variance is through the proof at the Board of Adjustment. Also, the letter by Cooch Picard, a representative of FFL, in which he asked for the zoning letter to be created, which was part of the record through that. And the public documents that they put out, we now have this zoning letter, which allows us to do these things based only on the zoning letter. Mr.
So
Picard.
is that their I guess what I'm asking is if that's their interpretation of what a philanthropic use is. Is that where that comes from?
Well, they don't say that until the lawsuit. They don't tie it into the philanthropic use. But Mr. Picard says.
So what do they tie it to? Because that's the only difference between that zoning letter and the office uses, as I can tell, or the medical clinic or whatever from 2017. Where does that come from?
Mr. Picard's statements to the public that are put in the record before the Board of Adjustment. Here's what we're going to do, and here's what we base it on.
And they felt like these fit within office use, right?
I can't imagine that they could. I think that
That's not what I asked. I asked what they thought, not what you thought.
I don't think they fit into office use. Point blank. I do believe they believe.
Did they argue that it fit into office use? You know, a doctor works out of an office. Related to the doctor is a pharmacist. The pharmacist may have an office in a broad term too. I mean, is that how they were arguing it fit within the 2017?
No, Your Honor, I don't believe it is.
Okay.
I believe they're saying, to Judge Golden's point, that it fits in a greater philanthropic use bubble that they would say is much larger than the office bubble. I would agree that a philanthropic idea is much bigger than the office bubble. I think there are many things on this list that appellees would concede aren't available under office. That's why they're forced to put it into its general philanthropic uses. And moving back to that point, we would say that was not under the original zoning. There's no grandfathering. That's all very clear in the record. That's not in the 1951 variance. It's not even in the 2017 variance. There was a staff report that mentioned philanthropic uses as a descriptive adjective. When the Board of Appeals in 2017 voted, that's nowhere there. They say you can do this, this, and this. And then they take a subset of those office uses and say, but you cannot do this, this, and this. Further, at the time, not only did they grant a zoning variance in 2017, they added to that zoning variance very, very specific language that if it's not acted on essentially within 2 years, and by acted on I mean building permit pulled and certificate of occupancy granted, then it lasts forever. They knew at the time there was not shovels in the ground. They knew in the time this was forward-looking, and they put a 2-year window on that.
Thank you, counsel. You've used your initial time.
Thank you, Your Honor.
Good morning. May it please the court, Robert Roebling from the Shelby County Attorney's Office. I am here for Shelby County, the Board of Adjustment, and the Division of Planning and Development. We also have here John Turner Jr. from the Crone Law Firm for the City of Memphis, and Locke Houston Waldrop from the Baker Donaldson Law Firm for the Friends for All Corporation.
Are you going to be,
I believe I am the only speaker. We've agreed unless they realize I have left something out.
okay?
The question in any common law writ of certiorari case is, was the board's action lawful, and is there material evidence in the record to support that decision? Plainly, it was lawful, and there is material evidence. First, I do want to address the Prosser's fears, this carte blanche fear of a carte blanche use of the property because of the zoning letter. At the Board of Adjustment hearing, the director of FFA, Diane Duke, stated specifically that there would be no homeless shelter here. No one would ever spend the night at that location. No soup kitchen, no needle exchange. In fact, FFA does not even do needle exchanges. And there is a 2021 state statute that prohibits needle exchange programs within 1,000 feet of a school or a park. Williamson Park, a public park, is directly behind this property. You see that on the map at Record Volume 4, page 483. Also at the Board of Adjustment, Lucas Skinner, the county planner and author of the zoning letter that we're talking about, confirmed in response to questions from the board chairman that those uses are not allowed and that those uses would be a violation of the zoning code. Unified.
Mr. Rowan, let me try to understand this, because it looks to me, the way I'm looking at these documents and whatnot, that the only thing we're talking about here is whether or not this term philanthropic organization should be used. Whether there was ever any history of this term philanthropic organization being applicable to the variances. And just starting with the complaint, the complaint says the 2017 use variance did not permit and therefore expressly excluded general philanthropic uses and or other uses not specified herein, including the non-office uses publicly announced by Friends for Life on the FFL property. And your answer at paragraph 37 was admitted that the 2017 variance did not expressly include the uses. However, 2 previous variances permitted or approved them. I don't think that's correct, is it? The 1951 variance gave a variance for institutional offices. There's never mention of any philanthropic.
That's true. This is because of the development of the zoning code. 1951, of course, was nearly 75 years ago and 5 zoning codes ago. There is no, currently in the UDC, the Unified Development Code, there is no headquarters use currently. And I don't recall ever having one in the previous zoning code either. The UDC was adopted 2010. The previous code was 1983. Now, the current definition, the only definition in the current UDC that fits the work of the Baptist Brotherhood, of Leadership Memphis, and of FFA, the Friends for All Corporation, the only definition in the UDC that fits is a philanthropic institution. That's the only use definition that fits this work. There is no other. And that's why in 2017, the property was, the use was described as a philanthropic institution.
My question is, why does there even need to be a variance if you have the 1951 variance that provides for institutional offices? You have the 2017 variance, which provided for commercial offices.
Right.
Why do you even need a variance? And there's no, it appears that the dispute here is over this term, philanthropic offices. And if they're not going to, if in fact there's no intention to use it for any other purposes other than for institutional offices or commercial offices, then what's the point?
Well, yes, exactly. There's not a variance here. The zoning letter is an advice letter to the owner. It advises him of the permissible uses on the property and those uses that are not permissible.
But it's using a term that was not in use at the time, and I think it's created an issue for these homeowners as to what in fact might be able to be used here. And it's just an interpretation by a planner, is the way I'm looking at it. There was never a hearing by the board that said that this is for philanthropic uses, other than this, as a result of this planning letter.
The philanthropic institution use first came up in the 2017 variance for office use. It was used to describe the current, existing at the time, use of that property.
It was not in the minutes.
It was not in the minutes. It was in the site plan that was adopted pursuant to the minutes.
But that language seems gratuitous in the site plan to me. Everything else that's in that site plan is contained in the minutes, other than this language about philanthropic institution that was added by the developer's planner on the site plan. That's the only place that exists.
Well, and again, the reason it exists is because it's the only definition that applies to Leadership Memphis.
Well, the minutes from the request for the variance for the 2017 minutes only talk about commercial use. It says it's requesting use variance to allow office uses. That was all that was requested.
Yes, that was for the 2017 variance.
Well, that's what the site plan was filed.
Yes, and the description of philanthropic institution was for the existing 1951, 1962, 1969 variances. That's the description of the existing uses, philanthropic institution. On top of that, said Mr. Skinner, the planner, we added the 2017 office use. So these are different variances.
But the only place that I can find related to this 2017 is this language that Mrs. Reeves included on the site plan that was filed in 2017 after the board issued its minutes. And the only request on those minutes to the Board of Adjustment was to allow office uses. So regardless of what you call it, that's all that they granted was for office uses.
In 2017, yes.
Well, that's what the site plan was. That's where this language from this subsequent letter came from. It came from that language on the site plan.
Yes, well, it was first in the staff report, which is issued to board members before the 2017 meeting, staff report analyzing the application. And then that same language is used in the site plan. Now, the site plan, isn't it? Yes, it's.
I guess what I'm trying to get at is that why isn't there just, if there's a problem with this as an interpretation, when there was never any minutes from the Board of Adjustment allowing anything but either institutional offices or commercial offices, why isn't there just a determination that it can only be used for offices? Instead of this opening up this Pandora's box and calling it something else, that's leaving it to the neighbors to try to figure out what's going to end up here.
Well, yes, Ms. Reeves addresses that point in her testimony at the board, which is paragraph 17 of our facts, 17 or 18 of our facts. And she says that we wanted an office use because the developer, Tripp President, was going to purchase the building, and he wanted to expand the possible uses. And she emphasizes again and again, we did not want to change the existing institutional uses because Leadership Memphis was going to remain in the building. In fact, it remained the sole tenant in the building. So she says, she emphasizes, we were not getting rid of the institutional uses, we were simply adding office uses to expand the value of the building.
So is this an admission that this property is not entitled to be used for anything other than office uses?
No, a variance is permanent. It runs with the land. It's not individual.
Well, the variance is for office uses.
In 2017, the 1951
Well, what's the
variance.
difference between that? That's apparently the rub here. What's the difference of what was granted in 2017, in 1951, in 2017? If there's no difference, if Mrs. Reeves is testifying that we just want to use it for office uses and we just want to expand its use for office uses, then why is there a difference between what existed in 2017 and what we're about here today?
Well, there's very little difference, actually. But they wanted the office to ensure that a user, a tenant, other than a philanthropic institution would be able to use that property. Offices includes lawyer's office, it includes doctor's offices, travel agencies, things like that. Those are not philanthropic institutions.
Well, in the 2017 allowed commercial uses, didn't it?
Yes, it did.
So what, commercial uses is not necessarily philanthropic uses, that's any use, isn't it?
Yes, but they're layered on top of each other. So now in 2017, in addition to philanthropic use, Baptist Brotherhood Commission, Leadership Memphis, in addition to that, they wanted office use, so you could get these private, for-profit offices as well.
Well, the variance that was granted in 2017 was for office use.
Yes, it was.
It even allowed a medical office or physical therapy office.
Right? Yes.
So what are we talking about? I'm trying to understand what we're talking about here.
Well,
Apparently somebody's confused.
Well,
The neighbors apparently are confused, and I'm trying to understand how limited this is. I think that's what they want to know.
Yeah, well, as we say, that their fears, we say, are not grounded.
Where does it say that in writing? Where
It
does
says
say
that, it says that in writing in UDC section 2.9 in these charts. The civic use category, it's called. That's philanthropic institution falls under that. And that would be in the record at about page 20, 25.
So are you stating to this court that this property cannot be used for any purpose other than commercial use?
No. It remains, philanthropic use remains viable, and that's why FFA purchased the property. The office use came from a private developer.
And what are you saying philanthropic use provides for?
It provides that a private, nonprofit organization that doing charitable or humanitarian work. Now, that's 1951. In 2017, you added private offices. So lawyers can go in there, doctors, therapists, those type of people.
So you have-
I'm sorry, go ahead.
No.
No, go ahead.
So you have commercial uses, offices, you have philanthropic offices. What's besides industrial, what's not permitted there? I mean, it sounds like that's very broad.
Well, it's limited by the descriptions and the definitions in the UDC.
Right, but you've already talked about medical offices and other kinds of offices, and we've talked about philanthropic.
Yes.
And so we've covered commercial and we've covered charity.
Well,
In terms of offices, what's left?
well, specifically as to the appellant's concerns, if you look at Record Volume 2, page 25, this is section UDC, section 2.9.4H. That describes social service institutions. That is completely different. That is where you get shelters and homeless centers, transitional homes, and things of that nature. Social service institution has never been applied to this property. It is not permitted at this property. That's why, in response to the questions from the board chairman, Mr. Skinner stated that no, if they did those things, those kinds of things, that would be a violation. They would be subject to citation to environmental court in Shelby
So
County's general session.
is that, in your opinion, is that what the plaintiffs are worried about?
That is what you can read in the transcript from the Board of Adjustment. So I would say not just my opinion, it is their words.
I'd like, when opposing counsel comes back, I'd like to hear him address that. Thank you.
Thank you. I'll address the 2017 variance lapsing. The building code provides, of course, that to get a building permit, you have to be building something. It sets out the grounds, the building code, which is separate from the UDC, sets out the grounds for issuing a permit. That's on page 16 of our brief. With no construction, there's no permit needed. No construction, no permit will be issued. And it's the same thing with a certificate of occupancy. And I see my time is up. Thank you for your time.
Thank you.
Thank you, Your Honors. To address very briefly what Mr. Rolling said about the no building permit being needed, the Board of Adjustments included that language in there. I've briefed it thoroughly that there's ways to renew that. There's ways to extend that period of time, but they put that information in there. Mr. Rolling said that the later developer in 2017 was attempting to increase the value of the property. I don't know this because the board didn't say it. All the board said was, we're putting this deadline language in there. But it may be, we understand you want to increase your property value, but you need to go ahead and build, and we're giving you 2 years. Judge Bennett, I would say that this is much more just a straightforward zoning issue than about the Prosser's fears, and I'd like to turn it on its head. The Prossers don't even know what to fear at this point. They have a zoning letter blessing Cooch Picard's exhaustive list, very long list of items that even Mr. Rolling says wouldn't be allowed. But FFL, one of the parties in the case, uses that to say, here's what we can do, and they did that at the Board of Adjustment. Putting it on its head, what the Prossers have asked for at every level of this case, and this is sort of the strange case that comes on several levels of appeal, to your honors, with that record in front of it. One extra layer of appeal than is usual. They want the property to be used for what it was allowed to under the zoning, residential. What it's allowed to be used for from the 1951 zoning variance, headquarters home. We've argued, and it's been fully briefed, and I won't go over here again, that the 2017 variance is forever lapsed and is dead. But even if it is not, the Prossers would say it can only be used for those things allowed in the 2017 variance. To believe what appellees are saying, you need to write out the language about the sunset, but then write in the language about a philanthropic use. Judge Golden, as you pointed out, that's not in the minutes. It's not in 1951. It's not in the 2017. That the word was used in some other format doesn't matter. If it's not in the minutes, It's not the change in the law that a variance requests. Even if it were there, and Mr. Roaring read it out very capably, that term philanthropic institution, it addresses a funding source, not a use. An organization distributing or supported by funds set aside for humanitarian purposes. The UDC, the governing document at this time, goes on to say specifically that it's not a use category. So I don't know that it quite can be cut down to this as an entire argument about two words, but it's not far from that. The processors have been put in a position where...
Let me pose a question. I've been listening to all this, and I'm trying to define the issue. What specific relief are you asking this court to give you? Because we've got a whole lot of stuff just swirling around, and I'm trying to pinpoint where it is that you think we can grant you relief.
Yes, Your Honor. So we have said in the broadest term, we'd like relief from the Chancery Court, which approved the BOA, which approved the zoning letter, all of which we think represent illegal, arbitrary, and/or capricious acts. The specific relief that my clients want is an adjudication, whether by this court or by the Chancery Court, that what's allowed at that property is the residential, the 1951, and we'd say stop there. Residential or headquarters home, period, point blank, stop there. But then if a determination is made either by this court or below that the 2017 variance was still in effect, which we strongly say is not in effect, then there'd be a two-part analysis. First off, it says what it says in the minutes, and that's how they make the law in that regard. It should be limited to that. And the second part of that analysis would be that this philanthropic institution language, again, we believe is made up out of whole cloth. It was a desire that instead of being brought by, and this gets into the due process issue, instead of being brought up in front of the Board of Adjustment or anything like that, was had a staffer do this letter, and then we're put in the position that effectively changes the law, or at least tells publicly what the belief of the department that the law is, and the processors then have to fight that and then have to go through all the procedure there. So the first indicia of any due process to the processors comes in the form of appellate relief at various levels. What they want, it should be residential or headquarters home, period.
Thank you.
Thank you, Your Honor.
Thank you. Thank you, counsel. We appreciate your briefs and your oral argument. We will take this matter under advisement, and we'll attempt to render an opinion at the earliest possible time. May be excused. In the interim, we're going to take a short recess to allow everybody to get where they need to be. So